Administrative decisions from the USPTO and the Copyright Office. Procedural matters relating to the denial of a patent or a trademark can be appealed to the Commissioner for Patents or the Commissioner for Trademarks and are reported in the decisions of the Commissioner for Patents and Trademarks, at least up until 1968 when they stopped publishing those books. But these decisions in those books are available to us through Hein Online in the Intellectual Property Law Library collection. Today, USPTO decisions are available on the PTO website in part because of the Freedom of Information Act. The FAO Reading Room links to all the different types of administrative decisions of the PTO. Final decisions from the Commissioner of Patents are organized by topic. Linking to the decisions on the subject of maintenance fees, we see these decisions are linked by patent number. Here's one decision. It looks a lot like a letter and is divided into background, statute and regulation, decision, and conclusion. It's signed by someone from the Deputy Commissioner's office. Final decisions from the Commissioner of Trademarks are divided into petitions from applications and petitions from registrations, which are identifiable by the first numeral in its designation number. This decision of the Commissioner of Trademarks is divided into facts, analysis, and decision. It is signed by the Acting Assistant Commissioner for Trademarks. Final decisions of the Patent Trial and Appeal Board from 1997 to date are searchable on the PTO website. To look at a representative decision, click on Retrieve Decisions from the last 30 days. The asterisk in the decision date column indicates that this list is sorted by decision date, but you could resort by any of the columns with arrows in them. This decision on appeal looks quite a bit like any reported decision from an appeals court. Some are short, some are long. The names of the administrative patent judges appear at the beginning of the decision, unlike the decisions of the commissioners. To browse rather than search PTAB decisions and the decisions of its predecessor, the Board of Patent Appeals and Interferences, use the links on the left of the PTAB Decisions page. Informative opinions are not binding, but illustrate norms of board decision-making. They are arranged alphabetically by party. This was an appeal of the rejection of some of the claims in a patent application by the patent examiner. Opinions designated as precedential are binding on the PTAB. The purpose of a precedential decision is to create a consistent line of authority as to a holding that is followed in the future by board decisions. Precedential decisions are clearly labeled as such. The PTAB has also set out a number of key decisions involving functional claiming, some procedural and some informative, as well as some decisions interpreting functional claim language in trial matters under the America Invents Act. And a collection of representative orders, decisions, and notices is also available. Final decisions of the Trademark Trial and Appeal Board are available in a searchable database. The sortable columns also represent the searchable fields of this database. Again, only those decisions labeled as precedential are binding on the agency. The TTAB can only determine the right to register, not the right to use. The TTAB is also responsible for cancellation proceedings against registered marks and concurrent use proceedings. Since 1978, registration is not required to have a copyright, but it is required in order to enforce a copyright through a lawsuit. The copyright maintains a searchable database of the copyright registrations since 1978. The copyright catalog of the catalog of copyright entries provides links to copyright renewal and registration records from 1891 to 1977. This is not a searchable database. It's a series of links to ebooks that are the registration records of the Copyright Office.